The arbitration appeal is allowed. The details judgment follows.
Yes.
If reply was most grateful.
Oh, this one.
Top.
Yes.
Page mention open. Number one.
One ARBP. It's a disposed of. I filed an application for modification. Can it go and file it?
Well, it means
I
modification.
mean, pardon my lord, it is a modification matter disposed of by my lord Chief Justice and CR Das, my lord. I have filed several memos, but it will not be listed, ma'am.
Not before us.
No, any bench may, my lord Justice CR Das remember.
The next sitting.
No, it will be, it has to be constituted. No?
Dear.
I beg pardon, your lord.
A, for clarification of modification of the Lordship's order and my Lord Justice author's order passed. Maybe it will be on Friday or on 3rd.
Well, bring that file. Let us see.
Pardon to mention, my lord.
Just to,
Pardon to mention, my lord. This is a PIL matter, my lord. Villagers of Kuruda and district of Balasore. Rights have been violated. The Gochar land has been illegally
it
converted.
will be listed on 9th of May. Keep the file.
9th of October.
9th of October, sorry, 9th of October.
3 October, 3rd October.
9th of October, nahi hoga.
About matter, I before Lordship on last Monday, CRL MP 1711 of 2023. Yesterday evening, I learned that your Lordship is directed probably on the serial. Your Lordship probably, what I'm given to understand, that is directed to list it in the serial.
Maybe.
And I,
What is the, I have not given any.
yeah, that is what I doubted, that is what I am making a mention. Probably the.
All right. Just give your number. Check up.
I have given the memo, man.
All right, just check up. Huh? It means-
To make a mention, my lord. One matter. This is the matter relating to transfer. The honorable signatures which passed the transfer order, and on the basis of said order, now steps have been taken to relieve the appellant, my lord. Can it taken up today, my lord?
No, it's not possible.
Pardon to mention, my
My
lord.
lord, Friday.
I beg pardon. Pardon to mention, my lord.
Huh?
Transfer matter, otherwise matter has become infructuous, my lord.
Transfer order has been quashed.
My lord, in that case, I'm for the respondent, my lord.
Your response means?
Here, my lord, petitioner, appellant is the respondent in that. My transfer order has been quashed.
Transfer order has been quashed. I don't understand. All right, come at 2, list at 2, give it before the.
I beg pardon to mention, my lord.
This is for restoration.
This will be come on the next month.
Pardon to mention, my lord.
Third week. Next week, third.
No. I beg pardon to mention. Let's give it on 11, 9th or 12 or 13 is not working day. 13 is also working day. Just keep speed over this. 16 also include now.
Pardon to mention, my lord. This is the relating to rehabilitation appointment matter, my lord. Your lordship also passed a judgment, my lord. This is left out matter, my lord. This is a left out matter, my lord. This is a left out matters, my lord.
No, what is the subject matter?
Appointment and rehabilitation appointment, my lord.
So when yesterday, whole week they are being taken, you will come as per your convenience.
Beg apology, my lord, could not so.
Already at 2, Justice House, no matter we passed, we got to Justice House. Rehabilitation, the covert matter.
I may be pardoned to mention, my lord.
Come at 2.
Oblige, lord.
Give the number to the state council.
Already given, my lord.
I may be pardoned to mention, my lord. One writ appeal. It was earlier dismissed, later restored on the application of the petition. I am for the opposite party. It was specifically directed to be listed on 14th September, my lord.
It is not listed.
It has not been listed.
It will come on 12th of October. Give the list.
I beg pardon to mention, my lord.
Pardon to mention, my lords. Well, the matter which actually should have come up before Honorable Justice D. Das, because today he is absent, my lords. Now, what has happened, my lords? The bank already notices have been issued. the petition.
No, Justice Das's matter will go to Justice K.R. Mahapatra.
Division bench matters.
Yes.
That bench has already commenced. If your lordship sends it across, because you
Just Mahapatra's bench, yes. You go then.
I'll mention it. I'll say that your lordships have sent the matter.
Give a note before Justice K.R. Mahapatra. He's just give the slip.
Yes. Deeply obliged.
Say before Justice Mahapatra. Justice.
Pardon to mention your lordship.
Just take the slip and submit before the court.
Can it be taken up before rising? Because he wants to redeem his entire mortgage. He's got the demand drafts also. He wants to pay back the entire loan, but the bank is insisted upon selling of the property today only.
No, just go there.
Yes, sir.
I may pardon to mention my lord. WPC 28775/2020. Though many memos has been filed, but it is not listed. The promotion matter, the junior has already been promoted. So it should be like
Okay, it will come on 16th of October.
6%. I may be permitted, my lord.
The 16th of October.
I may be permitted. Matter 2021. It should be listed to day after tomorrow, my lord.
Act 2, not day after tomorrow. Today, Act 2, otherwise you withdraw this petition because we will not touch any other matter.
All right.
Yes.
I may be pardoned to make a mention.
Today,
Pardon to make a mention, Lordships. The writ appeal was admitted by this honorable bench. It was fixed to 12/9. Lordships may pose this matter to Sunday for hearing, my lords.
16th October.
I'm obliged.
I beg pardon to make a mention, my lord. This honorable matter relating to honorable single bench, as honorable Justice B.P. Satpathy was concerned in the matter, so direction was issued to list it before any other bench. Direction was issued on 7th of August.
Till the DR judicial mentions before DR because bench has to be constituted.
After the signature of my lords, the matter is.
That is, go to the other bench and Chief Justice has to give an administrative approval. So place the matter before administrative side. We cannot do anything in judicial side now.
I made pardon. Writ appeal has fresh writ appeal. Or it has to be listed for fresh admission. Purely a money claim has been allowed by the honorable single judge. And now during pendency of the writ appeal, contempt petition has been filed. May be taken up day after tomorrow. Fresh admission.
Why not today?
Yes.
At 2.
Yes.
I beg pardon,
Well, fresh admission matter also.
Unless there is urgency, we will not take.
Well, there is a content matter on 3rd.
Already there is at 5th. Come at 5th.
I beg pardon, Miller. The writ appeal number 1745 of 2020-22. The Lordship, remember this matter was heard earlier. That is the taken over schools of local urban bodies school. Your Lordship fixed it to today itself. But it could not be listed.
Could not be because we are now asking the registry to list minimal number of cases. We are finding some difficulty. So it will come on 9th of October. Give it. It will come on.
My lord, with the leave of the court, am I audible, my lord?
Yes.
My lord, with the leave.
Yes, Mr. Sarangi.
My writ appeal number is 2225. My lord, I am deeply obliged. My writ appeal number is 2225. And I will be deeply obliged if your lordship will give me a chance to try my luck in this base, my lord, because hundreds of persons of diploma engineers of SESU who have been selected, the judgment.
They mentioned.
May be taken up on 3rd, my lord.
We will not take up any new matter where disposal is concerned. If you understand, no, why? I am just refraining. If you want
only because the persons have been selected and for decades long they have been fighting and the hopes have been shattered by the judgment of the single judge which has been fallen from half heaven.
But the state has challenged that judgment.
Miller, they were selected, Miller. These persons were selected. And they are waiting, they are fighting the legal battle. If I would be given a preference, I would prefer this bench, Miller. Because of your lordship generously, lordship may please list this matter on Tuesday and please kindly admit it. That much I must pray. I must.
All right, give the slip. Let us see. Bring the file.
This is a matrimonial appeal in which your lordship directed it to be listed yesterday, but it didn't come. Kindly the matter will be taken up on 29th of this month.
What matrimonial appeal?
This is a agency that the petitioner's son is not able to take admission after he has completed his 12th, but due to lack of funds, he is not able to take admission.
Go to the regular bench. There is a regular bench for the matrimonial appeals. All right.
First admission item number 1.
Yes.
May I please, your lordship.
Well, at item 1, your lordship had sought some instructions. May I seek a passover? The instructions will come by 12 o'clock.
All right. Come at 12.
Great.
Item number 2.
Item 2, my lords. So, appeal against the order of the learned single judge, my lords. Honorable single judge, I'm sorry. My lords, actually the order is against the third order where, my lords, what has happened? The petitioners had taken loan from EPICOL, which is a financial institution of the state government, my lords. And thereafter, my lords, it had become sick, so they were unable to repay the loan. So 2017, EPICOL initiated proceedings against the petitioner, and 2019 demand notice was issued against the petitioners to deposit the entire outstanding amount. They could not do so, and ultimately it ended up in litigation. The Honorable Single Judge also gave them opportunity to deposit these amounts, but they could not do it. Ultimately, the petition was rejected for extension. We only want 4 weeks time to deposit the entire amount, my lords. Failing which, my lords, the writ application may be dismissed. The writ appeal may be dismissed. And, my lords,
You just come, you are challenging the order dated 1/6/2023.
the first order.
No, come to this appeal, you are only challenging the order dated 1/6/2023 at page 12.
Yes, my lords.
Yes, you just read the para 4.
Accordingly, the writ application is disposed of, directing Liberty to deposit 7 crores 11 lakhs as per annum within a period of 1 month from today. And in such event, OP number 2 shall consider the prayer for settlement of the loan amount in respect of the petitioner.
So you are already given the 1 month's time.
Yes, my lords. Time had been given to us, but we could not stick to the time schedule, my lords, because, my lords, this was a huge amount.
So unless we hear this IPICOL, that how can we extend the time?
My lords, what I'm simply praying for before
this organization had any standing counsel in the High Court?
Generally, Justice Mr. S.K. Paduri appears for EPICOL.
Ms. S. Mishra is the assistant standing counsel for the state.
No, I am appearing for the state, opposite party.
No, in the order some Ms. S. Mishra's name is there.
One of the additional standing counsel.
He was the additional standing counsel before the Honorable Single Judge.
Okay.
Generally, Mr. S.K. Paduri appears for EPICOL.
You can, if you can bring him, we can try. Otherwise, the matter will be listed on some other day.
We'll inform him if he is able to come, my lords. Otherwise, some other date the matter can.
Better we fix the matter on 5th of October. 5th of October.
My lords, they may auction the properties in the meantime.
I don't think so. Within 5 days, is it possible to auction a property?
My lords, actually, that is our apprehension. We are, my lords, ready and willing to deposit the entire outstanding amount as on date within 4 weeks.
No, because you are already the default.
We are a defaulter, my lord. That is admittedly we are defaulter.
First an interim order, but I cannot.
My lord, may kindly see another order. My lord, friend is not.
No.
18th August. You place that order. That is in your favor.
18th August it was extended.
It was extended for 4 months.
4 months. We not stick to the time schedule.
That is, now he wants further extension.
I want a further extension. That is all. It was extended for 4 weeks. Otherwise, EPICOL will auction the properties.
Because you are failing. You have become the.
No, I know, my lord. So he has failed twice.
Twice, thrice, everything it is appearing. For long, you are Just in the finance, it is not permissible. Court cannot allow the jurisdiction also.
I understand, my lord. He has been a defaulter twice.
Several times, Mr. Kanvi, you know, Supreme Court says
This is the last order.
we shall not go in favor of the defaulters.
No, true, my lords. Defaulters should not be encouraged, my lords.
5th of October, try your luck.
As a last resort, my lords, if he will be given an opportunity to redeem his mortgage, my lords.
Go to the bank only.
Epicol, my lords, is not a bank, it's a financial institution.
Whatever, the mortgage has been created with them.
My lords, otherwise let it come up on some other date. I'll ask Mr. Party to appear so that
5th of October.
Something.
And you just inform them the matter has been fixed on 5th of October.
We'll inform
Please
them.
don't take any action.
Yes,
that will not be there.
Your lordships may just observe that.
Mr. Milan Kanangul and Senior Counsel. You are Mr. Dhal.
Yes.
Registered by Mr. Dhal and Counsel appearing for the appellant. Stop. Let the matter be listed on 5th of October. On 4th. October 2023. Stop. We direct Mr. Dhal and Counsel appearing with the appellant to serve a copy of this appeal to IPICOL by those three.
Epical. Council for
Epical.
No, I don't. I'm saying IPICOL I have written. Epicol you may say, but I dictate that it will be written as EPICOL. All right. IPICOL by those three, by 29th of October 2023. Stop. You are appearing, Mr.
Yes, my lord. For respond our
First state.
By 29th September. Matter is coming on 5th. Mr. D.K. Mohanty, learned Regional Government Advocate, has appeared for the
respondent
number 1.
Item number 3.
Deeply of response. I'll inform Mr. Party that. Yes, sir. I'll inform. Deeply of response.
Item 3.
None appears.
My lord, I am appearing for the respondent, full response.
None appears. Who is appearing?
Yes, my lord.
You are appearing or not?
Yes, sorry, my lord.
So we'll issue notice on the limitation.
My lord, I am already appearing. My lord, I have absolutely there is no ground, my lord. I have also filed an objection already. My lord, your lordship, my lord, this is a pensionary benefit matter, my lord. Already seen in that, my lord, just 1 minute. My
lord. I have a very simple query.
Yes.
How can you file the objection?
My lord, because my lord, I filed a contempt application.
No, how can you file the objection in this proceeding? We have not issued any notice.
No, when I came to know about the filing of the
you have the right to file the objection.
No. I have filed the objection because
this is a very simple legal question.
Yes, sir. I have right to file because
positions of the proceeding.
No, my lord, what happened, my lord?
It's not done.
My lord, what exactly happened, my lord? When the order was passed, I filed a contempt application.
We understand your anxiety. We have not issued any notice. You are filing an objection. What objection then? Objection only can be filed. You can issue the show cause. We have not passed any order. The entire this order sheet is blank.
Yes.
All of a sudden you have filed an objection. At least regard the procedure of the court.
And that 2 IAs are there. 2 interim applications are there. One for condonation of delay and another for dispensing with the certified copy. In the meantime, I have submitted the certified
copy. If you have
copy.
Serious objection, then we are fixing the matter for hearing. I am issuing notice.
Your lordship, if your lordship allow me 2 minutes, your lordship can hear.
No, we will not allow because we have no time.
So Acharya, we are asking you if you have any objection to the condonation of delay.
Serious objection, he filed objection.
No, actually, my lord, your lordship may kindly have a glance. Then
If you have objection, you will be heard. That is what. If you don't have, we will condone and then we will hear what you have to say.
then your lordship may condone the delay, but absolutely there is no ground has been assigned in the delay
Then
application.
let it be heard.
You are taking a risk, you file an objection. Do you have your client's instruction?
Yes, I will file an objection.
Better.
Do you have the client's instruction to say that I have no objection?
No. I will file an objection to. I have
So
already.
stick to the objection. Don't say that I have no objection all on a sudden.
No, I have filed an objection already.
Not objection to the limitation. My lord is saying whether you want to
I for condonation of delay.
I will file an objection.
He has filed the objection in the
Sorry,
and two eyes are there.
Okay, this readable, you have no right at all to file such objection. So I am issuing notice on the limitation.
Well, since I have appeared your lordship, I will take the
Yes, copy will be given to you.
Everything will be given to you since you have appeared.
Yes.
Mr. M.K. Kuntiya. Press 3.
1897.
That is where I ask. First, IA 5128 of 2023. But Mr. Kuntiya and Council, Additional Government Advocate, appearing to the applicant, appellant applicant, there is an application for dispensing with the filing of the certified copy in preferring the intercourt appeal.
In the meantime, I have filed the certified copy.
Yes, intercourt appeal. That certified copy has been filed within the period of limitation? No.
No, man. On 14/9.
So they will raise again another objection.
Once that stamp will be been
That IA may be dispensed. That
is I am dispensing with that period will be covered if I already dispense. Challenging the order dated 21st December 2022, passed in WPC number 5469 of 2022. Stop. We find no difficulty in dispensing the filing of the certificate copy at the time of filing the memorandum of appeal. However, Mr. Kuntiya and Council has, Additional Government Advocate has pointed out, in the meanwhile, they have filed the certified copy. Stop. Accordingly, this application stands allowed and disposed of. Next. 5126. Mr. Sajjan Sach is an application under Section 5 of the Limitation Act for condoning the delay of 201 days as per the stamp report in filing the intercourt appeal against the same judgment. Stop. Issue notice as to why the said delay shall not be condoned or any other order shall be passed in the circumstances of the case. Since Mr. Acharya, you are Mr. A.Q. Acharya, when counsel appears and waves notice for the opposite party, no formal notice is called for. Mr. Acharya prays for a short accommodation for filing the objection. Accordingly, the objection prayer stands allowed. Let the matter be listed on 16th of October, 15 days, October 2023. Meanwhile, the opposite party shall file objection if any, no further accommodation will be made. Mr. Kuntiya, Additional Government Advocate, is directed to supply a copy of all the interlocutory applications along with the memorandum of appeal to Mr. Acharya. Stop. There is another application for stay of the judgment.
So let it lie over my lord, because after my objection.
That is, I am also issuing similar notice. We file the objection.
Yes.
Right? Yes. Same order. Huh? Filing the objection. This is an application for staying the impugned judgment challenged in the intercourt appeal being WA number 76. Obliged.
Item number 4.
Item number 4, yes, there is a noting that the IA has been wrongly typed. It is not correct, madam. They have not, the section has not
Correct.
read it for correctly.
It has come only for that.
Only for that. Your lordship has rightly observed the, they have quoted the number of the miscase per stay, but your lordship has issued the notice in leave to appeal.
Okay.
Your number is correct, my lord. It has been typed correctly.
Again.
Mr. Aki,
Number has been typed correctly by this honorable court. But office has given a wrong note.
What
Note of the office is wrong, man.
this has pointed out to us, the office note dated 22nd September 2023 is not correct. This in the order dated 15, no, it is 15.
Yes, madam.
September 2023, the case number, the I number has been correctly typed. Registration will correct the order. So next, what is the other purpose it has come?
Only for
No, for this purpose only. They thought that is the miscase filed past for stay, my lord. They thought that is the miscase.
No, list the matter on the date fixed.
Item 5.
My lord, in item number 5, I have received instructions from the authority that after this order your lordship has passed the last order, they have issued letter to the vice chairman BDA, and that was the direction of the honorable court. The chief engineer has issued letter to vice chairman BDA and again director of sports. There was a survey in the meanwhile, and preliminary they have this sketch map at page 4 of that document list. Kindly see, they have prepared. And yesterday also there was a meeting by the vice chairman BDA to explore the possibility of doing anything which will protect the interest of the petitioner. So your lordship may give me 10 days time. I will come back with a proper affidavit.
But you shall not disturb the status quo of the field in the meanwhile. Both cannot go together.
My lord.
No, if constructing the road, then the next day you said we have to break the road. A lot of government money will be wasted.
No, road is not now being constructed, but what I gathered information from them that as per the newly modified plan, we will give them better facilities, and by taking the road on that year, we will give them better facility and better field. And for that purpose, this sketch map has been prepared.
Better field means the same field.
Or more land.
More land they will be given.
Contiguous to the land or where? It will be
contiguous. That is
but on the other side.
Other side.
Okay.
That is a possible solution.
My lord, if your lordship will give me half an hour, the chief engineer, I have asked him to come.
But wait for some time. Let us wait.
Because he is in another court for his.
All right.
He will come within 20 minutes. 20 or 30 maximum.
Whenever he comes, you be there, Miss Mishra.
Yes, sir. The last matter, so we'll wait. Whatever it has to be taken up.
There is no. Or your lordship may fix it 10 days. After 10 days, we will give
it. Before you just take a decision, because it is also a tentative proposal.
If your lordship is proposing to pass any interim order,
you just check up whether engineer is freed by this time from the court. Otherwise,
what I saw now, the item number 19 is going on in court number 3. His item is 23.
Always let him come for 5 minutes.
It will reach and he will come.
Ask the council that he is attending the court number 1, he will immediately come.
Immediately he will come.
No, you are not getting my point. Let him come here now. And mention before that court, within 5 minutes he'll be released from here. 3 matters are away.
Come from the other building.
That will come right now. It's a personal appearance of the chief engineer in that court. So, contempt matter. So, within 10 minutes, now it is 20.
We are coming back at 12.
12, obliged. Oh, at 12, that item number 1 is also fixed.
Come at 12.
Yes, sir.
Yes. Obliged.
Item number 1.
Well, as I've received instructions that 644 vacancies are available.
Yes.
So Lordship had noticed that this is a genuine case. On the last occasion, the petitioner has actually got 74.1% and it was wrongly calculated to be 64%. If I leave it to your Lordships.
Already give us the little brief fact so that we can pass it on.
Will Lordship kindly see Annex 3, page 17.
Anisha?
3, page 17. Para 3, Hindu Madhav Sarkar scored 73.44%. Deepak Kumar Das scored 73.35%.
Okay.
Your Lordship kindly see page 27.
This is page
17, my lord.
And that para 5 of page 17. His representation is there, but no action can be taken because OA is pending. Then what page did you say next? 37?
Page 27, my lord.
27.
Under the same annexure?
No, my lord. That is annexure.
3,
my lord.
Okay. This is also annexure.
Same annexure.
annexure.
Sorry.
That is what I am telling.
Sorry. Same annexure. Page 27. Hindu Madhav Sarkar, Deepak Kumar Das, your Lordship kindly see serial number 5 up to serial number 35. Government in the counter stated that up to serial number 35 were given appointment. Hindu Madhav Sarkar was serial number 5, Deepak Kumar Das serial number 6. My position is serial number 53. Wrongly calculated 64.39.
Up to 35, they all get appointments.
Up to 35, they get up.
So 66.31%.
No, you are not SC, I think.
SC, all petitioner and Hindu Madhav Sarkar,
all SC.
SC.
All these people are SC.
SC.
Page 27, everybody SC.
This is SC list.
You are at serial?
My serial number is 53.
53.
My lord. Sanjay Kumar Mandik.
Only one petitioner.
My lord, one petitioner.
Petition.
Ranking, wrongly given a ranking 416. Had they correctly given my position on the basis of percentage, my position above Hindu Madhav Sarkar.
Deepak.
We are comparing serial number 5, 6 and 53.
Serial number 5?
5, 6 and 53.
53 also got the appointment.
53 is the petitioner.
No, 53, no, that is the end of petitioner. And the last person is at 35.
Is at 35.
Is 66.31.
Government in the counter before the Honorable Single Judge admitted that up to 35 serial number got appointment.
Okay. Correct percentages?
Well, at page 28 is his certificate.
So what
is 74.1%.
Oh.
28.
Page 28, annexure 4.
74.1. Then so he would have been at serial number
4.
Yes. 5.
5. He would have been at 5.
5 after 4.
But in page 28 is a mark sheet of the State Council of Technical Education and Vocational Training.
Yes, of this petitioner.
Well, out of total 3,000 marks, I have secured 2,223. That is 74.10%.
Okay, that you have calculated.
Minor. But they have calculated that wrongly 64%.
That is why.
Well, I admit that there is a genuine calculation mistake on our behalf.
All right. And what is the stand in the repetition, the counter affidavit?
Well, it's in the counter affidavit we had stated that this sponsoring of names through from the panel stopped in 2012. In 2012, a new rule was framed, and that the new rule will govern.
Okay.
That was the stand in the counter affidavit, and that has been upheld in the judgment at Annexure 11. The learned single judge in another case, in another writ petition, has upheld that stand of the state government. That writ appeal is pending. Annexure 11 is the judgment.
In that case, my lord, in Santosh Kumar Mandal case, the honorable single judge held that instead of giving appointment from out of the panel, the state government issued advertisement for filling of the said post. The honorable single judge refused. In the instant case, my lord, petitioner junior was given appointment. In that case, my lord, they are below in the panel. And in the meantime, advertisement was made and new rule was framed. Therefore,
in that batch case, advertisement for direct recruitment was being challenged without giving these people, they are diploma engineers. Diploma engineers, I think some of the posts are reserved for them. Right? That has been done away with.
That has completely been done away with. Now it is all direct recruitment.
Understand.
So they
but the recruitment he had participated in, that time you were doing that sort of recruitment.
System.
But because of the wrong calculation, he has not.
Your Lordship, please.
So he had immediately challenged that. And from then it is pending. Or he came later.
Immediately, after appointment was issued.
So
after knowing the fact on the RTI Act.
2016 he has challenged.
So when did you do away with that practice?
2014 was the last recruitment year.
2014. His recruitment was which year? Which year he participated?
February 14.
So 2014.
The last sponsoring of names through the panel.
So he had participated in that.
Your Lordship.
All right.
All right.
So he challenged it in 2016.
But doctors
J.K. Lenka.
J.K. Lenka, Learned Counsel, appealing to the appellant. Also heard Mr. Arnav Behra, Learned Additional Standing Counsel, appearing to the state respondents. The appellant, having noticed that his score has been inadvertently shown lower than what he had actually secured. And as a result, even though he got much higher marks than the last person who had been appointed, he was not appointed.
Up to 35 is securing less marks.
In the writ petition, he has urged this court to appoint him in the post of junior engineer civil on the basis of his passing out year 2008 in terms of the government policy decision made for empaneling the diploma holders, civil engineers. Stop. For such appointment, it has been asked to leave time frame for compliance. Learned single judge. Which one is the order?
Well, order is
11.
page 42, my lord.
78, common order.
41, page. 11 page 42.
Annexure 10.
Learned single judge. By the order dated 22nd November 2022, passed in WPC OAC number 3821 of 2016, has dismissed the writ petition observing that the issue with regard to sponsoring candidates from the panel has already been decided by this court in its judgment rendered in WPC OAC number. What is the OAC number?
2645 of 2014.
2645 of 2014.
And batch.
And other cases in the batch. So, in the SID, Mr. Dr. Lenker and counsel appearing for the petitioner, appellant, is quite emphatically contended that learned single judge could not navigate the code of the challenge. So, challenge is linear and apparent. So, the appellant has also annexed the mark sheet of the State Council for Technical Education and Vocational Training to show the total marks the appellant got in the final examination So, out of 3,000, the appellant got 2,223. And as such, the percentage of marks is 74.10%. 110.
74.10.
So 74.10 in place of 64.39. Is it 63.39? 63.39, which has been shown against the appellant at the time of sponsoring the names to the department. So, Dr. Lenkel and Council has taken us to the combined tabulation sheet part of Annexure 3 to this Memorandum of Appeal. By the later dated February 2014. It has been contended by the state respondents before the learned single judge. The serial number 1 to 35 of that list were sponsored and appointed. Stop. Are the person at serial number 35 had received total
66.31.
The total mark is 2484. Total mark
2487.
2487, i.e. 66.31. Stop. Consider the marks reflected in the petitioner marks sheet. Annex 4 to the Memorandum of Appeal. Petitioner ought to have been placed
at serial 5.
At serial number 5. As the person is the serial number 4, and serial number 6 got, as the persons at serial number 4, 5, and 6 got the following percentage of marks. Serial number 5, 73.45. Serial number 6, 73.35. And serial number 7, 72.72. As that has not, as the, by mistake, the petitioner's percentage shown lower than actually what he had secured. His name did not figure in the proper position, i.e. serial number 5 in that combined panel. Stop. Mr. Behra Lanet, Additional Standing Counsel, has clearly submitted that this is an error apparent on the face of the records. At the same time, Mr. Behra has submitted that the system of sponsoring the candidates was replaced by the rules.
Odisha Diploma Engineer Service.
Yes, I am giving it.
Odisha Diploma Engineer Service, Method of Recruitment and Conditions of Service, Rules 2012.
By the rules called Odisha Diploma Engineer Service, within first bracket, Method of Recruitment and Candidate Conditions of Service, close the bracket, Rules 2012, which came into force with effect from 1/4/2014. But the selection process with which we are concerned with, it took place in the year 2012. 2014, before the said rule came into force. Stop. As such, the said objection has no relevance in the present case, though the writ petition was filed in the year 2016 by the petitioner only after mining out from the records of the said mistake. Stop. The state is under obligation to correct the record reflecting the percentage of marks actually the appellant has secured, and to incorporate his name in the proper place. Stop. But that exercise may not be necessary if during fixation of the seniority list this aspect is taken care of. Because seniority list on the merit panel will be there. For all purposes, petitioner's appellant's position in the combined merit list or the tabulation sheet as indicated by us would be at serial number 5, showing that has secured 74.10%. Stop. Huh? Okay. Stop. The petitioner shall be appointed within a period of 30 days from today in the post of the diploma engineer, no? No.
Junior engineer.
For the junior engineer diploma, what is the post?
Junior engineer civil man.
Junior engineer civil with effect from
36-14 others were appointed.
These people.
Others people, this
with effect from 13/6/2014.
36
when the person at serial number 6 of the said merit panel was appointed. Serial number 5 in the said merit panel, which will be reframed by virtue of our order. That is it. Before the merit panel is reframed, no? Serial number 5 before the merit.
Serial number 6 was appointed.
No, we are not changing. We said the position we are talking about the before the merit panel is reformed. Reframed, sorry. Stop. We also further state that since the petitioner did not work in the post, though he will be appointed with effect from what is the date you told?
36-14.
13/6/2014, be appointed, so says. But till he is actually appointed, the period actually appointed, the period between the date of appointment or the date of the order of the appointment and the actual the date of the appointment we have directed shall be notionally counted, and the petitioner pay shall be fixed on the day when he would actually join. Stop. In this direction, we set aside the impugned order of the land single judge and allow this writ appeal. No. What is the peculiar effect?
May I pray for one clarification, Your Lordship? Your Lordship may only say that Your Lordships have not made any observations on the order in WPC OC 2645 or 14.
It is not required because we are correcting factual. It is the consequence that follow.
Your Lordship, please.
So I unnecessarily invest time. Okay.
One thing I wanted to Lordship. And permission,
it may be also directed that the merit after merit will be refreshed also within 3 months from the day from today.
Initially they were appointed on contractual basis. In the meantime, they are continuing on a regular basis. That line
that will automatically follow.
So at par with the.
All right. If the person is appointed on 13/6, you said
2014, 36/2014.
14s are regularized by this time for serving a certain period of a certain length of for serving a certain period. The petitioner shall or the appellant shall also be given the similar benefit. No, that is to follow. We are in direction.
Grateful.
Item number 5.
Yes, Mr. Monty. Have you checked up this map?
Yes, Your Lordship.
after your lordship passed the last order, there are many developments and we have already planned. The sketch map has already been given to your lordship. The lordship may see. And accordingly, the meeting is going on and the chief engineer is also there. He can appraise your lordship the current status. And
that is your proposal. That is a probable suggestion that can happen.
Your Lordship.
I don't find you have any reason to object to
Your
that.
Lordship, now a new fact has come into our notice, Your Lordship. As far as we understand, in that meeting also, there was a suggestion that to the left of the ground, Your Lordship, they are going to extend the field, Your Lordship. That will cover a road that is nearly of about 70 feet and a police station is there nearby, Your Lordship. But then in the meantime, it has come to our knowledge that there is another order of this honorable court, which has with a direction to the concerned Tehsildar that without the 40 feet, if the 40-feet road is ever encroached, then there will be a traffic issue, Your Lordship. And to the south of the playground, there is certain house.
All details now, they have surveyed the area. They have given a concrete proposal. I find that is quite excellent.
Your Lordship, that will lead to a second round of litigation, Your Lordship.
We are passing the order. Let there be litigation. There is no end to litigation. But we have to come to a reasonable point.
Yes, Your Lordship. I understand. But Your Lordship will look into the orders that I have been providing, Your Lordship.
Already give this order. We will clarify this order. They have definitely taken the care of all these orders, I think, when considering preparing the map.
Your Lordship, we do not have the copy of the affidavit.
no affidavit is filed, only 2 letters. You can see.
This is the order of the collector.
Your Lordship, that is
Order of the collector.
Your Lordship, that is by WPC number 21693 of 2019.
Vote of the collector and such and such. On the representation,
Yes, Your Lordship.
ultimately the collector is exercising the power.
Your Lordship, because this in the writ petition number 21693 of 2019.
Writ petition only asks to represent consider the representation.
Yes, Your Lordship.
Considered.
Yes, Your Lordship.
All right. Our order will just prevail over everything. Why are you showing this?
Your Lordship.
This order has nothing to do in this PI.
Right.
The lordship will prevail upon all these orders.
Yes. But she is correct. There may be a conflict. May not be conflict because they are taking care of all these things.
All the facilities which are present there.
Collector is the part of the team who will be considering all these things. So obviously, you should know.
This road has been constructed for access to that same stadium.
Yes, Your Lordship. The same stadium and also the houses, those are behind the stadium. Our only contention is we have been provided.
What is your contention about the citizens' amenities or about the stadium?
Your Lordship, we are actually pressing before you both the points, Your Lordship, because if the ground is again taken to the left, Your Lordship, the citizens that are there to
I'm telling you one thing, because I have served at least 8 states as the High Court judge. This is for the first time I'm coming across. The government has come down at that level. Otherwise, there's whatever happened, we'll go to the Supreme Court. Let us do it.
Your Lordship,
You appreciate the conciliatory approach.
Your Lordship, I just brought into Your Lordship's knowledge that this.
I think you agree to that, but they have not finally decided it. They will go through the administrative process.
Yes, Your Lordship.
It's yet to be done, sir.
Then I understand.
All the facilities, the road, the stadium, all the facilities we are trying to reorient everything so that none of the facilities are compromised.
I think this efficacy of the playground also will be enhanced.
Yes.
The way you provided
That is enhanced.
So why you're objecting? You should welcome it.
Your Lordship, I'm not objecting, Your Lordship.
You said that you should welcome it, but I've said we finalized it through the meeting. Matter ends there. But we have to balance between the two public interests, right?
Yes,
and this is the best proposal that can come. That is why I passed that order that how somehow adjustment can be made or not to explore.
Yes, Your Lordship.
I'm recording that you are happy. Okay. So you just take further action on this proposal.
Yes, sir.
Date okay.
Disposal.
item 5.
At our request, Mr. Manoranjan Mishra, Chief Engineer, DPI and Roads, Works Department, Government of Orissa, is present in the proceeding in person. As per the decision taken in the level of the Works Department, Mr. Mishra has produced a changed produces the modified,
Yes, ma'am.
The reverse, modified and revised allocation of the land by protecting the playground on the reference, and also reference and making the necessary adjustment. It appears from the map that the additional land has been allocated for expansion and development of the playground also. The map is annexed with the letter dated 31/8/2023 is addressed to the Director of Sports and Youth Affairs Department by the Chief Engineer, DPI and Roads, Orissa. So, Ms. Bini Mishra and the council appearing for the petitioner has stated that the petitioner will not have any objection if the proposed modified area allotment initiative by your adjustment is acted upon for the construction of the link road. Is it link road? What is called?
Ring road.
Ring road.
Ring road with its other adjunct ring road with what is this other part is called this embankment. With embankment stuff. But Mr. Mishra has clearly submitted that the said proposal is awaiting for the administrative approval, and that would follow by the follow after consultation of the Bhubaneswar Development Authority,
Yes. And sports.
and Sports and Youth Affairs Department. But he has expressed that those authorities may not have an object because the main project has not been disturbed for this reallocation. All right. We keep these communications on record for future reference. So, on accepting that there will be no change in this land allocation and the road alignment with its embankment, we close this writ petition on observation that this suggested modification and modified and revised plan will not invite any resentment. So, we also place our appreciation for Ms. Mishra, who has assisted to reach this decision. So, in terms thereof, this public interest litigation stands closed. However, stands closed. We would request the petitioner, which is a sporting club, to cooperate with the department for construction so that unnecessarily obstruction is not created. No orders to cost.
My lord, I am appealing for PDA, my lord, on this instance.
I am appearing for BDA, my lord, OP2, my lord, planning.
BTA, sorry. Mr. M.A. Pradhan
On behalf of Mr. Mahapatra, my lord.
appears for the Forestry Development Authority on behalf of Mr. D. Mahapatra, platform sale.
Matter listed for to be mentioned. Item number 1, WPC 339 of 2017.
So release from Parthard, list for hearing. So, same in the next case. Also.
Item 2, 4013 of 2021. Item number 3, WPC 18042 of 2021.
Order passed every year, no? Same order.
And WPC 16303 of 2022 with 16302 of 2022.
Yes. You just check up the record, no? With the order, we send the record back to the registry. Okay.
Page mentioning page 1, item number 1 to 5. My lord, serial number 4. Serial number 4, I seek some time. My lord, reason being I filed an IA for amendment. Some typographical errors are there and one document was there for amendment which is not in the list.
All right.
Let that be incorporated.
At the request of Mr. G.N. Parida, no?
Yes, your lordship.
And counsel appearing to the applicant, let the matter be listed on 16th of October.
My lord, along with that IA for amendment.
It will automatically listed.
My lord, highly obliged.
So the matter will be listed on 16th October.
Obliged. Yes, admission. Memo.
So I'm making a mention for the third time this matter regarding the institution being already declared as public and a part of the prayer being already infructuous. Lordships had heard it on 18th as the last matter, and I had made a mention on Monday and it was allowed. And
the histories are, your matter has not been listed.
No.
Tomorrow I am giving this Friday, there is no division bench.
Also, the Lordship.
Go to the next month, first week.
Next month, first week.
4th of October.
4th of October. Lordship, also there is a matter in which Honorable Justice Savitri Ratho and your Lordship were assigned, specifically assigned. It's a matter pertaining to enhancement based on the payslip of April 2022. The same was called for by the family court, but when the enhancement was done based upon the previous payslip.
Any bench can take up the matter. Now the Justice Savitri Ratho and Justice Sahu is hearing this matter. Mentioned before their bench, it will come. They are the assigned bench now.
I'll do that.
All right.
Obliged.
One matter, which one is very urgent, and only don't give the matter. Only this matter that will be listed on 4th of October.
4th. Grateful.
Yes, admission item number 1.
May I please, Mr. Veda? Annexure 4, at page 68, the order passed by the Honorable Single Judge is silent here, my lord. The Honorable Single Judge has directed the present appellant to pay the arrear wages for the period from August 2020 till the disposal of the petition. But relying on the letter issued by the appellant number 2.
What is the order? This is your challenging an interim order.
Yes, but IA has been disposed of.
No, unless what is the direction in which paragraph?
But page 68, annexure 4.
Just annexure 4.
Annexure 4.
Yes, I'm looking at the judgment. You give the
Yes, but the direction, Lord, paragraph 8 is important, the observation.
Read the 8.
From the discussion made above, admittedly the petitioner was in service as a daily wager as on the date of passing of the interim order dated 6/1/2020 in IA number such and such, which has been admitted in the objection filed in response to the present IA as extracted above, and the said order is still in place. However, no IA has been filed till date by the contesting opposite parties for variation of the said interim order passed by the coordinate bench. Rather, a stand has been taken in the objection that the petitioner has been disengaged with effect from August 2020, for which he is not entitled to any wages after July 2020. The said plea, that is important, the said plea taken in the objection by the opposite party is contemptuous, being in contravention of the interim order dated 6/1/2020, passed in IA number such and such, which is still in effect, being extended from time to time, and the said order was last extended by the order dated 16/8/2023. And Lordship kindly see paragraph 4 of my writ appeal, the interim order I have quoted.
These are passed in the earlier IA.
My lord.
There is, though the petitioner is continuing in service of DLR, this part.
Yes, but
basis against the vacant post by order of such and such, have not released his wages from August 2020 till date.
Yes.
The interim order granted by the Honorable High Court is in force. As a result, he and his family members have.
Yes. Thereafter, my lord, paragraph 11 of that informed order needed to mention here that if the order is not complied with within the stipulated time frame, the officers who are presently holding the post of Transport Commissioner and Chairman, State Transport Authority, opposite party number 3, and the Regional Transport Officer Bargad, opposite party number 4, shall remain present in person before this court at 2 p.m. on the adjourned date to show cause as to why so much to contempt proceedings shall not be initiated against them under the Contempt of Courts Act for non-compliance of this order. Matter be listed on 3rd of October. This is the order. Lordship may see the interim order passed by the coordinate bench at page 5. Page 5, I have quoted
in your memo of appeal.
Mine. The order dated 6/1/2020 it had counsel for the petitioner and law and AGA for the state. As an interim measure, this court directs that in the event petitioner is continuing in the post of peon, he may continue as such for a period of 6 weeks from today.
Your case is that he was not continuing.
But he was continuing till July 2020. Thereafter, he has not been engaged as a peon. And this is the stand taken in the objection. And Lordship kindly see, the writ petition has been filed by the respondent challenging the sanction of abolition of Group D post.
No, just because the writ petition is pending and you have not grievance. Your grievance is very focused on this. First of all, there is two aspects of the matter. The way the learned single judge has interpreted this order dated 6 January 2020, that according to you, there is an objectionable because it is not omnibus. Only if he is continuing in the post, he will be there.
All right.
All right. You have not been restrained by for any other reason that you cannot disengage or you may continue or like that. Now you have disengaged him.
Yes.
All right. So this order was continued 6/1/2020.
But till date, that order has been continued.
But what is the meaning of this interim order? He may continue as such for a period of 6 weeks from today.
Yes, but that order was passed on 6/1/2020.
And thereafter,
that order was extended on 18/11/2020.
Or how it was extended? Do you have a copy of that order? Because this order actually, if any no order is passed, after 6 weeks, this order lapses.
Yes.
So whether
That is my case.
Huh?
That is my case.
Then this order was not extended in that way.
No, next extension is 1811, 2020. By that time, after July, from 1st August, he has been disengaged, the respondent.
After the expiry of that 6 weeks?
Yes, ma'am. After expiry of the 6
weeks. And he is not attending the office?
No.
Are you sure?
Yes.
Alright, so we are admitting it because the other party has to be heard. Otherwise,
well, Lordship.
Mr. Behera, additional government advocate, you are additional standing council, no?
Standing council transport.
Standing council transport department for the appellant. This intercourt appeal has challenged the order dated 38/2023 passed in IA number 12189/2021 arising out of WPC number 29144 of 2019. Stop. Mr. Behera, Current Council having referred the impugned order dated 30th August 2023 has submitted that the said order, while passing the said order, learned single judge as general single judge did not read the order dated 6 January 2020, passed in IA number 185/2019, and its continuation. So for purpose of reference, we would like to reproduce the said order dated 6/1/2020, page 5 of the memo. Just take the order out of here. Stop. Mr. Behera and Council has submitted that the said interim order was in currency for a period of 6 weeks from the date of the order. True, it is that appellants have disengaged the respondent number 1. When you disengaged on?
From the month of August 2020.
No date specific?
No. DLR employee, no date.
All right. Sometime in the month of August.
Not allowed. He is not allowed to work any duty.
Disengaged means disengaged. I'm not terminated another thing. Disengaged in the month of August 2023. 2020. Stop. As a behavioral council, learned standing council has further stated that the said order dated 6/1/2022 was not extended. Stop. Only on, what is the date next order?
18/11/2020.
Only on 18th November 2020, the said order was extended. What was you extended? Was extended. Stop. But taking the but the London civil judge by the interim by the order by the impugned order has inter alia observed as follows. There are 8 of the judgment. Having observed this, the opposite parties numbers 3 and 4, where the appellants number 3 and 4 here?
Appellants.
Now the appellants number 3 and 4.
2 and 3.
Comma, the appellants number 2 and 3 were directed to release the salary of the petitioner till date within a period of 4 weeks from today, from the date of order, and to ensure payment of his monthly wages regularly every month till disposal of the rate petition. Mr. Behral and Council has stated that the respondent number 1 did not bring to the notice of the court about his disengagement before the interim order was renewed on 6/11. What is the date you told me? 18/11/2022. After the said interim order was passed, the IA number 12188 of 2021 was filed. For directing the opposite parties number 3 and 4, within bracket, the appellants number 2 and 3 in this appeal, to release the wages of the petitioner with effect from August 2022 till date, with further prayer to direct the opposite parties to pay the monthly wages regularly in every month till disposal of the writ petition. Mr. Behral and Council has categorically stated that after the month of August 2020, the respondent number 1 never worked with the appellants. And the said order is on the basis of, while passing the said order, the relevant facts were not taken into consideration. So, by the order, impugned order dated 30th August 2023, a single judge is also observed that observed at para 11 of the said order that if the order is not complied with within the stipulated time frame, the officers who are presently holding the post of Transport Commissioner cum Chairman, State Transport Authority within bracket opposite party number 3, and the Regional Transport Officer, Burger, opposite party number 4, shall remain present in person before the court at 2 p.m. on the adjourned date to show cause as to why suo motu contempt proceeding shall not be initiated against them under the Contempt of Courts Act 1971 for non-compliance of the order. Stop. Having noticed the nature of controversy raised in this appeal, we would admit this appeal to be heard on merit. Admit, issue notice, returnable on 3rd of November 2023. In the meanwhile, the impugned order dated 30/8/2023 just in the meanwhile, just this part. In the meanwhile, this is under IA number 6636. This is for stay, I think. Yes. 6663 of 2023 shall remain suspended, but the respondent number 1 shall continue to get the wages, monthly wages, subject to filing an indemnity bond for any reason. The court decides against him, he will be liable to refund the entire amount that will be paid in the meanwhile. So where the question of non-compliance is concerned, the said clause of the order is stayed until further order. Stop. So we direct the respondent number 1 to file a short affidavit in this appeal, showing the records of his presence in the workplace since the purported disengagement. Stop. That apart, it is made absolutely clear in view of the interim order that you have passed involves the payment of the wages and as such on the returnable date. This appeal will be heard on merit. Stop. Steps for service of notice shall be taken within 3 working days from today by registered post to AD.
I'll receive notice for respondent number 2.
So since Mr. M.K. Kuntial, an additional government advocate, appears and waives notice for the respondent number 2, no formal notices called for. All right.
Connected matter, same
situation.
Same.
Person is different only.
Person different.
Just make it same way, you know?
Item number 2. In that case, IA is different. IA number will be
IA number.
IA number is taken and give the IA number accordingly.
Please,
page 30 minutes is the order of the Honorable Single Judge, which is essayed here minutes. The order starts at page 39. Now, minutes, prior to that, Lordship may kindly to come to page 38. The present appellant before your Lordship is the opposite party number 4, the Residents Welfare Association Managing Committee, so and so. We have been arrayed as an opposite party number 4. Then your Lordship.
38.
Running page 38 minutes. I was only pointing out that item 2. Item 2.
Okay.
The reason is I was only trying to point out minutes, alluding to the fact that we have been arrayed as opposite party number 4. And minutes, page 39. This matter comes up for the first time. After on which date the court disposes of the matter, finally. Heard learned counsel appearing for the parties. The writ petition involves, we have not yet put in our appearance there. Writ petition involves the following prayer. Petitioners therefore most humbly pray that your lordships may be graciously pleased to issue a rule 9C, calling upon the opposite parties to show cause as to why the impugned amendment of the bylaws at Annexure 6, dated 12/6/2022, and consequential declaration on 5/3/2023 at Annexure 7 shall not be declared as illegal and be quashed. Further, as to why the opposite party number 3 shall not be directed to dispose of the representation dated 27/3/2023 under Annexure 9, submitted by the petitioner. Third, and as to why the opposite party number 3 shall not be directed to appoint an administrator to manage the day-to-day activities of ZIRWA, that's the association, and including the conduct of election. Further, as to why the enhancement of maintenance charges and collection of additional amount from members in the association towards corpus fund for capital expenditure with effect from 1/4/23 shall not be declared as illegal and shall not be quashed. And if the opposite parties fail to show cause or shows insufficient cause, the said rule may be made absolute and for any other. Then minutes paragraph 3. Mr. So-and-so learned counsel appearing for the petitioners at the same time brings to the notice of the court that though the Annexure 9 at the instance of the petitioners pending consideration of the ADM come additional register of societies, Bhubaneswar, opposite party. Considering the pendency of the representation at the instance of the petitioners before the opposite party number 3, expressing its anxiety that the representation submitted on 27/3/2023 should not have been kept pending for nearly 5 months. This court directs the opposite party number 3 to take a lawful decision of the same in the involvement of the petitioners and also in the involvement of any party likely to be affected by the outcome of the proceedings. Lawful outcome be shown also involving the grounds in the writ petition as well as the materials supported therein within a period of 2 months from the date of communication of this order, along with a copy of the writ petition by the petitioner as well. Now, this order is completely in the teeth, my lords, of this 11A. 11A, my lords, this amendment, Orissa Act, my lords. Orissa amendment comes in. We have annexed that, my lords, that your lordship would find at page 28. Running page 28 minutes, we have annexed the amendment.
Okay.
11A. On the teeth of this provision, minutes, in the event of any dispute arising amongst the members of the society in respect of any matter relating to affairs of the society, including election, continuance of an office bearer in the society, any member of the society may file a petition in the court of the senior civil judge having jurisdiction over the place at which the office of the society is situated, and the said court shall, after making necessary inquiry, pass such orders as it may deem fit, my lords. Now, my entire my humble submission before your lordship is this, my lords, that this, my lords, on the face of the prayer, my lords, this is a contentious matter. Obviously, my lords, respondent number 4 being a party should have been at least been noticed. Had we been noticed, my lords, we could have brought it to the notice of the Honorable Single Judge that this is a matter not for the ADM to decide, but this is a matter for the civil judge to civil court to decide. the contentious issues raised by the my lords writ petitioners would involve my lords adducing of evidence and other thing. And in view of this amendment which has come in my lords in 2021.
When the election?
No, election is not there, my lord. We are continuing.
Continuing, legally continuing, or term is not over?
My lords, that
because if you continue beyond the time, it's an illegal continuation.
No, they have stated at para 20, page 20 of the writ petition, para 13, that the managing committee is not
given even notice.
My lords,
you are not given notice.
Not only notice, not noticed at all.
Admitting the petition, but don't expect an interim order from this court.
My lords, the whole thing will be in the event, my lords,
nothing would happen because the court has a power to dislodge even the elected committee also.
Well, that is, they are not, my issue is not election or anything. Whatever happens, my lords, whatever orders passed should have been, at least, my lords, we should have been noticed. We could have brought to the notice of this honorable court, honorable single judge, that any disputes raised, the language is, my lords, any dispute, including continuance or election, has to be tried by the civil judge. So therefore, ADM can register is not the authority. When the law has carved out in 2021, post 2021, my lords, ADM loses his power to try all these issues, my lords. Thereafter, my lords, any order is ocious, my lords.
Society. Look at his volume. This kind of thing.
I'm sorry, my lords, Honorable Justice Saw, my lords, I don't have second copy. I'm sorry.
All right. We're finding out. Should be National Council hosted by, what is your good name?
Ananya Pradhan. Miss Ananya Pradhan.
Hosted by NS Ananya Pradhan. Good. Mr. Pradeep has already outset. Refer to section 11 in respect of the resolution of disputes, which was brought in statute by the Orissa Act number 10 of 2021. Lastly, by the Orissa Act number 10 of 2021. So this section reads as follows: 11A, resolution of disputing board, in the event of any dispute arising among the members of the society in respect of any matter relating to affairs of the society, including election, continuation of an office bearer in the society, and member of the society may file a petition to be in the civil court, in the court of the senior division civil judge, senior civil judge, having jurisdiction over the place at which the office of the society is situated, and the said court shall, after making inquiry, pass as ordered as may be such order as it may deem fit. Step. According to Mr. Palit, the additional district magistrate within bracket, the deputy registrar of societies, in view of this legislative changes, doesn't no more hold the power to settle any dispute, doesn't hold any power to settle dispute, settle intra-society dispute. So, but the largest civil judge without taking note of the section 11A and also in absence of the present appellant,
The application was pending before him, he was not deciding it. Obviously, before the ADM as the...
What is the order of the single judge?
The Mr. Pradhan, learned counsel appearing for the petitioner at the same time brings to notice of this court through Annexure 9 the representation at the instance of the petitioners pending consideration of the magistrate, additional registrar, society of the additional district magistrate come additional registrar of societies Bhubaneswar, number 3. Considering the pendency from 27/3/2023 should not have kept it pending for nearly 5 months. Obviously, after the passing of the amendment, the ADM was obviously
single judge is observed.
So this court actually clothes him with the power to decide something.
This court has directed the opposite party number 3 to take a lawful decision on the representation dated 27/3/2023 in respect of the involvement of the petitioner and also the involvement of the petitioner and also in the involvement of any party likely to be affected by the outcome of such procedure. So, it has been further directed that such a decision shall be taken within a period of 2 months from the day of communication of the order. So, Mr. Pali, therefore, legislative council has submitted that when there is a statutory remedy for resolution of the dispute, ADM cannot hold the power of adjudicating, cannot hold or willed, was the adjudicatory personal body. Despite that, the above order has been passed.
Next sentence, my lords. Lawful outcome be shown also involving the grounds in the writ petition as well as the materials supporting therein within. So the entire, my lords, power has been closed. He has been directed to exercise that very power which the statute takes away.
So, further, Mr. Pali, Senate Council has submitted that the way this order has been framed, the entire writ petition has been disposed of. That next is there has been
disposed of on the same day.
Stop. It's just not that. This
on the first day.
But stop. Without any notice, just this party not given. Without any notice to the appellant, the said petition was disposed of. Stop. Admit. Issue notice. Since Mr. P.K. Muduli, learned regional government advocate.
Yes, only 1, 2, 3 on my learned friend.
Why 1 to 3 only?
1, 2, and 3 on my learned friend. 4 to
appealing to the opposite parties, respondents number 1, 2, and 3.
And the rest minutes notice. 4 to 31 minutes notice.
1, 2, 3. And as no formal notices called for about those respondents, the petitioners will take steps for service of notice on
4 to 31. 4 to 31.
All the remaining respondents
remaining
within 3 working days from today. Yes, sir.
In the meantime, He'll go ahead and carry out the direction, which would mean he will be adjudicating the very same thing which the civil court would have done. The last sentence, my lords, that he will refer to the materials, grounds raised in the writ petition and pass a reasoned order, which means he'll embark upon an adjudication there. And that is exactly what is, my lords, will be on the teeth of section 11A. And we were not noticed while the order was passed, my lords. This is directly to our prejudice. And he was not deciding it.
Number 6673 of 2023. Huh?
Next matter.
Next matter.
2406.
File number. Is I number? It's 24858 of.
The number 666 of 2023. Flag A. I8 flag A. Flag A.
File number 3662 dated what is the last flight? On the responsible 3 working date the list of 5020. Then to case number I established. It has been apprehended by the appellant applicant that if the impugned order in WA number 2406 of 2023 is executed for any reason, the entire regulation will be infructuous. No, the entire appeal will be infructuous. So what we have noticed that without notice to the petitioner, it said order has been passed. So in that view of the matter, issue notice, returnable silencers, steps for service be taken. Except of the respondents number 1 to 3. 1 to 3 for whom Mr. P. K. Mugirmi uncommented that is appeared. So meanwhile, the operation of the impugned order dated 6662/ there is already the
23/8/2023
has passed in WPC number 124858 of 2023 shall remain suspended. So if steps for service the same way now shall be taken.
Great.
Urgent certified copy be
urgent certified copy. Good.
November. Also 6th November.
Item number 3.
Well, petitioners on behalf of the public has the grievance that some persons are entering in the government land that is Guchoro by Kisamo. In nature, that is Kisamo. And
Hello, can you see the representation at page 40? In fact, there is no mention of any plot number, over which plot number there is an encroachment. And also the name of the enclosure.
The name of the enclosure I have mentioned in the below. On the
come to this annexure, this representation dated 28th July 2023.
the name of persons that is mentioned. My lord, beg your pardon, I have not filed the translated copy, but I am reading on Facebook व्यक्ति such and such are disturbing. They are added as opposite party number 6 to 9, and they have given representation with the collector, sub-collector, and tahsildar. That is by postal means that is annexure 3 and page 17. That is the postal receipt.
We revert it for inquiry.
Depends on the subject. Subject is, they should not, the persons which are the allegation is that they have enclosed the land should not be settled. When there is a provision for settlement of the land.
That is, that cannot be section 7 or
whether someone is encroaching the gochar land, if any action has been taken against him, all right. If not taken, they should take the action.
It appears from the representation as well as from the body of the reputation. They have submitted application for settlement of those enclosed land.
In their favor?
Yes.
Petitioner?
No, in favor of the encroachers.
Okay.
That is being objected by this petition.
Where?
There is a statutory remedy. Act, they can approach.
That is, see, Odisha Prevention of Land Encroachment Manual, that is Act, section 7.
Under the Odisha Government Land Settlement Act, there is a provision for de-reservation of the gochar land and for settlement of those lands in favor of the landless persons as well as homesteadless persons. There is statutory remedy, so they should avail that.
How they can they can avail the statutory remedy appellate provision, those is agreed by the order?
No, not agreed. Prior to de-reservation of the gochar land, there will be a public notice. At that point,
no, they are not saying it is de-reserved and they have encroached. This is the gochar land as if there. Some people has encroached that land and nobody is taking care of that.
As it appears from the representation, there is an application for settlement of those lands.
Where?
Those gochar lands.
Where it is mentioned in the representation.
ଏହି ଜମିକୁ ସରକାରଙ୍କ ତରଫରୁ କୌଣସି ଅବରୋଧକାରୀଙ୍କ ନାମରେ ସେଟଲମେଣ୍ଟ ନ କରିବା। They pray that this enclosed lands.
You are anticipating. You are taking an anticipation.
Always.
Some persons are encroaching the gochar government land. I have given the representation. My limited prayer that the opposite party government authority.
You are Mr. Patnaik.
Das, SP Das.
Or Mr. SP Das and counsel within the petitioner. This is a public interest litigation for forbearing the opposite party's number 6 and 7.
6 to 9.
6 to forbearing the opposite party number 6 and 6 to 9. As they have encroached the gochar land. So despite filing of the representation, Annexure 3 to the petition, the competent authorities have not taken any action. Hence, this petition issue notice returnable on 3rd of November 2023. Steps for service shall be taken on the opposite party's number 6 to 9.
My lord, beg your pardon. In the mean, I am disturbing. That the annexure may kindly be disposed of, but
no, that because these people have a right to hear, because we pass in any order, he is there on encroachment. Let them come and then. You want the disposal of your representation.
Man, I'm saying that necessary opposite party government authority, particularly Tahsildar and collector, to hear both sides and settle hear the matter.
Then we cannot write the word oust or the.
My lord, I am.
Or just go out. Keep the name of the party lawyer. Stop.
It will be better if minors direct they let them appear and file the counter, it can be disposed of.
Yes,
they have not filed any application for settlement.
No, this is all right. Whatever these just you see what I ordered first. The allegation has been made in this writ petition that despite filing of the representation, opposite parties number 2 and 5 are allowing some allowing the respondents number
Six to 9.
Just what is the line? 2 to 5 has not taken any action against the encroachers. Stop. Mr. S.P. Das, Land Council, agreeing to the petitioner, has contended that the land in question falls within the category of gochor, which except in the public interest, cannot be de-resolved. So, but if the scheme is lifted, it will be apparent that the petitioner wants eviction of the private respondents. This court cannot pass any order without hearing those persons. However, with the request of Mr. Das, Land Council, appearing to the petitioners, has submitted that his representation dated 28/7/2023, addressed to whom?
Addressed to opposite party collector, sub-collector,
addressed to these
Tahsildar 2, 3 and 4.
Addressed to the opposite parties number 2, 3 and 4. Was not considered, and hence this petition. We direct the opposite party number 2, 3 and 4. Still make your opinion number 4 to cause an inquiry about the allegations filed in the petition and take the appropriate action that available at law. So such representation shall be considered within a period of 6 weeks from today.
From the date of communication order.
Always from the date of the communication of this order by the petitioner. So Mr. Petitioner, in the above terms, this petition stands disposed of. A copy of this order be furnished to Mr. P.K. Mudali, London Additional Government Advocate, for transmission. All right.
Okay. Item number 5. This matter, that Kondagara matter, on the last occasion you received directed me to prepare a note and But on the last occasion, 30th August order.
Who is appearing for the state in this matter?
Yes, Mr. Behra was appearing. Even then, on the last occasion, it didn't accept the reasonings by the Tahsildar. So, for the ROR reflection of past entry in the earlier 1935 ROR, and it also didn't accept the case of migration, and also not a case of SCVC. And the relied upon the 2011 inquiry made by the SCRTI, which made the inquiry in my video specifically also, and in the Western Odisha, Bargad and Balangir districts. And the ultimate conclusion was that these people are Kunda Doras, and Dora is only honorific title and is not have a impact on the caste social status. Now, on the last occasion, my friend raised objection that it's a migration. It's a case of migration.
I think it will take time. We will not touch upon this case. We will fix it on 5th or 4th according to your choice.
Only, my lord, little prayer, my lord. The petitioner, the respondent, Subham Dora, is taking admission in medical college.
When is the medical admission time?
Time already gone, my lord. Now it is third counseling. I'm at serial number 141 in the ST rank. If I, University directs, impugn order, learning single judge, and single judge directed to issue caste certificate within 4th week, that has been, University directs, the caste certificate may be issued, which may be subject to outcome of the final result, so that the career of the student will be.
No. Status cannot be inquired into so in a shortcut manner.
No, it is inquired upon.
No, why you are waiting so long? You should have approached the authority for much before.
No, I
are fixing the matter on 4th of October.
Merit, that may be. I am saying, Merit, what I say, the London single judge in the impugn order directed to issue the caste certificate.
No, that power we don't have. London single judge has that power. How a court can direct to issue a caste certificate? It is a process of inquiry.
It was inquired upon, Merit. It was inquired upon. The revenue inspector has given report in my favor. But he didn't accept it. The London Tahsildar didn't accept it and didn't issue it.
Yes.
That's why I came up to this report.
This is the report of the revenue officer is bound to, is a binding of the Tahsildar.
No.
He has the authority, he has the right of whether accepted or not. How the court can without inquiry? Otherwise, you can directly go to the state level scrutiny committee. They will do the necessary inquiry and they will come a finding.
That will be a cumbersome process. My application will become.
No, that will be cumbersome process. So you are coming late in the court.
They have filed appeal.
I know, but you have approached the last single judge also little 23 only. When have you filed the petition?
I filed the application immediately on 6th May. It was rejected. The London Tahsildar. Immediately I filed appeal, writ application.
Okay, this appears 6th May you have filed.
Yes, 6th May it was taken up.
Mr. Muduli, what to do? Single judge says the issue cuts with tribe certificate.
Under challenge.
That is under challenge. What about the future of the boy?
Some shortest date. Friday.
That you allow this respondent to appear in the counseling.
Ultimately, minors came to the conclusion he is not entitled to the reserve category challenge.
No. This we are fixing the matter on 4th of October. In the meanwhile, he only appeared before the counseling. Right?
Already appeared.
But it will be kept separately.
Already appeared before the counseling.
At 141 serial I'm at. So the moment the caste certificate I produce, I will take admission. So the admission, let the admission taken, which will be subject to outcome of the year's decision.
What is the last date of the admission?
Last date?
According to the medical council, now the medical council is. What is the state? The director of medical education has fixed the date for admission.
I don't have any instruction.
No.
The last date.
By end of this month, it will close. 141.
It is the 30th September. Earlier it was there. But whether that system is still following or
yes, it is being still followed. Otherwise, the student will not get admission now, my lord.
So what I pray, my lord, let the child, the respondent be admitted. I do lose it, my lord, I don't claim equity. My seat will go, and which is not possible. My uncle has got certificate. My grandfather has got certificate.
He will not get the seat.
Huh? My grandfather has got certificate.
One eligible candidate.
My grandfather got certificate. My own uncle got certificate.
But your father doesn't have the certificate, his certificate is cancelled.
Now, since the issue was raised, now the appeal was filed.
Only question you left question me in the teeth of the cancellation of the father, how can the son get? That was the only question. Now the father has also come before your lordships, and the order, impugned order, so far as his case is concerned, without jurisdiction.
It is a state pool.
Yes.
Admission.
State pool. The whole year will go, and he cannot. Now he also.
You are fault also. These issues are not that you do not know that early, but you are approaching the court, waited for up to May when the Tahsildar will cancel. When I applied for the certificate,
I applied this first certificate in the year 2020. That was not rejected. I came up to this on 4 occasions. Repeatedly, I approached this honorable court. Ultimately, the honorable single judge directed in the ultimate direction matter, in view of the NEET examination, the Tahsildar is directed to forthwith issue the caste certificate on.
What is the basis of this direction? That is the question.
The basis of direction was he rejected on the ground of ROR. The ROR I produced independently of my father also I produced. One caste certificate, one record of right of my grandfather, Ganesh Dora. One ROR I produced of my father, which is independent plot. Third is the caste certificate of my kith and kins. All my blood relatives.
But can you file the affidavit?
In fact, Mr. Behera has prepared the written note.
That will see. Where you can file the affidavit? Have you filed the affidavit with the last single judge?
Appeal is there. We have also filed the writ appeal. That is the lead case.
No, that is the. Have you filed the affidavit with the last single judge?
Yes, yes.
They filed. Okay. Mr. Counsel, you are appearing for the respondent or
respondent? Sole respondent.
Appearing for the respondent. Shubham Kumar Dora. Stop. By means of this appeal, the order dated 3rd August 2023 in WPC number 160/069/2023 has been challenged. According to Mr. Murali, the single judge, without giving any reason, has passed the order to treat the Now, when single judge has directed the Tahsildar to treat the petitioner belonging to the Kondagora, which is recognized as scheduled tribe, as the petitioner's grandfather had certificate in acknowledgement of being a member of the Kondagora, a recognized scheduled tribe. So, the state has filed this appeal against such direction. Mr. Mishra Learned Counsel, agreeing with the sole respondent, has submitted that there is no dispute that the grandfather of the petitioner was a tribe known as Kondagora, and which is recognized as a scheduled tribe. As such, the petitioner is entitled to get the benefit of ST status in respect of the medical admission in the medical college. So, it has been stated by Mr. Mishra that the petitioner has got a rank for medicinal admission. If he can produce now the status certificate within the status certificate, he will immediately get the admission. As such, he has asked that subject to hearing of the appeal, the petitioner, writ petitioner, so the writ petitioner may be allowed to take admission in the medical college subject to the outcome of the writ petition. So,
page 41, paragraph 4, stand in the comparative.
It is a father's case, no?
No, not father's case. Because they belong to SCBC category.
Again,
the petitioner belongs to Telangana caste.
And that is what recorded in the record of right.
No, that is all right. That is because so Mr. Muduli has further submitted that in the government records, it has been shown that the family of the ancestors of the petitioner or the petitioner do not belong to the Kondagora community, but they belong to Telangana community.
And they migrated from
state of Astral Andhra Pradesh, and they said the petition cannot be treated as scheduled tribe. So, be the receipt made. We admit this appeal to the hardened merit. Issue notices returnable on sentences since Mr. Muduli Learned. Since Mr. Mishra, Legal Minister, and Council appears and notice for the sole response, no formal notices called for. Right. In IA. Mr. P.K. Muduli and Council is pressed for passing an interim order. Now, this the second IA is what is the this?
No, he has prayed for the stay of the order. So the units have directed the subject to outcome of the writ appeal hearing. But actually that order was passed in writ appeal and as well as in IA.
What is that order?
IA he has filed.
Whether we admitted this appeal?
IA number has not been given.
That order is very big order.
Yes, that starts at page 25. Dealt with all, Honorable Single Judge has dealt with all the aspects. The other writ appeal matter, the father's writ appeal, that also listed along with that 2257. If you let's looks at it, I'm sorry, 2257. You let's see, kindly see, that is father's appeal.
No, 2257. It's a your appeal is not going for the time being.
Yes.
Have you made this director of medical education a party here?
Director was not a party in the writ petition.
So on whom will pass this direction?
To the Tahsildar. Tahsildar, he will issue caste certificate so as to produce it before the medical authority.
What you will do with the caste certificate cannot be part of the direction. Sorry. If you come for a specific purpose, it is required, we can pass order. But director of medical education is not a party here.
No.
So that this admission part will not come.
Admission, no. Only the caste certificate part. Only the caste certificate part. The learned single judge has directed to issue caste certificate, which may be issued subject to outcome of the final hearing. That is my little prayer.
And when is the last date? Whatever.
September, madam. End of September.
So September is over.
Over, madam. The moment it is produced, I will take admission. I have given the affidavit.
No, that is not direct. Today is 27.
It is possible, madam.
I will not direct. Whatever possible, I know. We
Yes.
not direct.
Yes. Madam, I have
Because it will be actually, if you say that whatever they say, it will be giving the final relief to you. The appeal will be infructuous there. That we cannot do.
The eligible candidate, suppose tomorrow the writ appeal filed by the state is allowed, the eligible candidate which is eligible for admission
That is the
will
one.
be decided.
I have given the rank method in the original petition, writ petition itself. Giving the affidavit.
No, the basic principle of passing of any interim order that the interim order should not actually dispose of the writ appeal.
Right.
That we cannot do.
Right, madam.
So if you ask them to issue the caste certificate, what remains in the appeal? They are complying the order of the learned single judge?
Not yet complied.
Not if I pass the interim order, that will be the compliance of the learned single judge's order.
Yes. But
we are fixing on 4th of October for final hearing. Right? No, main.
Correct. Can it be 6th, any date after 4th?
No, it come on 4th because let us, it should be decided for a Not all these matters you are not required to hard service of people. It has been stated by Mr. Rana Behral and Additional Training Council appearing to the appellant that the impugned order as passed by the learned single judge is not based on any dependable data or records. Stop. On the other hand, Mr. Digambar Mr. Lanet, counsel appearing for the sole respondents, has submitted that the grandfather of the petitioner has been shown as a member of Kondagora tribe, and as such, in the record of right, also he has been shown accordingly. So the later on, the record of right was corrected by deleting the caste name, and it has been recorded by of that amendment correction is Telenga community. Telenga.
That's Kondadora, my lord. Corrected to Telenga, from Telenga to Kondadora.
The said entry of Kondadora has been made by a correction in the ROI. So, the ROR is a record which can be relied on for purpose of proving the status of the person. So, the earlier, we observed that the father of the respondent number 1 was not granted the.
No, his caste certificate was cancelled.
Earlier, we observed that the certificate of the father of the respondent number 1 was cancelled, but the said order was never challenged by him. Mr. Mistral and Council has submitted that the father of the respondent has filed a writ appeal against the order of the learned single judge, by which order of the cancellation was not interfered with. So, the same writ appeal is
W2257.
2257 of 2023. So, the said appeal will be registered along with the present appeal on 4th of October for consideration. Till then, the Director of Medical Education be approached to keep one medical seat vacant, subject to the decision that will be passed. No, subject to the. No, don't just got it off. Till then, one medical seat from the scheduled earmarked for the scheduled caste community shall not be filled up, but the competent authority may issue the provisional admission to the person according to the present situation. So it is made absolutely clear this provisional admission shall be subject to the outcome of this present case. So,
may I only pray, can it be 6th October, but not 4th?
6th October.
6th, great.
Past interim order. That will be, I'm just explaining. You can make the provisional admissions to anyone.
Your Lordship, please.
But you
are deeply grateful. I have filed my written note of submissions. A new aspect has also arisen in this case. I have mentioned it in my written note.
Now, then the note, by note, it cannot you file a short affidavit there.
Your Lordship, I'll do that.
In the meanwhile, the appellant is given leave to file a short affidavit for bringing about facts relevant for purpose of adjudication.
But in fact, this new aspect is the ground on which the Tahsildar had initially cancelled the certificate.
Because they are not also recognized in Andhra Pradesh as the.
In Telangana, the entry is Konda Dhoras and not Konda Dora. So if you cannot claim Konda Dora status in Telangana, then there is no question of that claiming that in Odisha. It is my short word.
It's not a case of migration even, subject to whatever he said in affidavit.
It is an admitted fact.
All right.
No, not admitted. I never.
Already you have said it decided. They say this is information. Produce the information.
Matter listed on special notice, writ appeal number 2442 of 2023.
Your Lordship, kindly turn to page number 66, order dated 3/6/2023.
Second copy.
Page 66, my lord. Order dated 3/6/2023.
You are there on record? Are you there on record as a counsel?
My lord.
What is your good name?
Babita Kumari Patnaik.
Okay.
Sri, may I read, my lord? Sri G. Kartikeswar Pradhan, present appellant, my lord. Assistant Executive Engineer Civil OB and CC Limited is deployed to.
Yes.
Sri G. Kartikeswar Pradhan, present appellant, my lord. Assistant Executive Engineer Civil OB and CC Limited is deployed to Digopahandi R&B subdivision under Ganjam R&B Division 1 by Sri Narayan Behera 2, Assistant Executive Engineer Digopahandi, R&B subdivision under Ganjam R&B Division 1 deployed to OB and CC Limited until further order. Second, my lord, Sri Narayan Behera 2, present respondent number 5, my lord. Assistant Executive Engineer Civil, Digapahandi R&B Subdivision under Ganjam R&B Division 1 is deployed to OB and CC Limited. Vice Sri G. Kartikeswar Pradhan, Assistant Executive Engineer, OB and CC Limited, deployed to Digapahandi R&B Subdivision under Ganjam and R&B Division 1 until further order. Respondent number 5 challenged the said order before the Honorable Single Judge, my lord. Honorable Single Judge had directed to consider his representation. Considering his representation, opposite parties have rejected their prayer on 7/6/2023, my lord.
Is it the prayer of opposite party number? Respondent number 5.
Respondent number 5, my lord.
Okay. Then?
At page 98.
Then?
You also kindly see the rejection order. Rejection order, page 99 is the relevant portion. Second paragraph, my lord. And whereas the petitioner, present opposite party number 5, respondent number 5, my lord, in his representation at annexure 8 to the WPC has requested to modify this department order number so and so dated 3/6/2023 and to allow him continue in Digapahandi R&B subdivision or post him in R&B wing of the place like Bhubaneswar, Khordha, Panikoili, Dhenkanal, Anugul and Jagatsinghpur. And whereas the petitioner has not been transferred from his present place of posting, that is Digapahandi R&B subdivision, by the impugned order. Rather, he has been deployed to OBC Limited basing upon the grievance petition filed by him before the Chief Secretary Odisha through Janashunani portal by registration number so and so dated 23/5/2023. Copy and clerk for his transfer to place nearby Cuttack or Bhubaneswar on health ground of his wife. And whereas Sri G. Dandapani Pradhan, father of Sri G. Kartikeswar Pradhan, who is the substitute of the petitioner, filed a grievance petition before the Chief Secretary Odisha through Janashunani portal by registration number so and so dated 23/5/2002 with a prayer to transfer his son to Digapahandi subdivision of Roads subdivision under Ganjam R&B division on the ground of his old age ailments, and a transfer of on health medical grounds of spouse dependent family members is within the ambit of the transfer policy decided by this department at point number 6 of the department.
What is the ground? Tell me.
Here, my lord, in pursuance to transfer order dated 3/6/2023, present appellant joined in his place of posting, my lord. Thereafter, he joined on 7/6/2023, my lord. Present respondent number 5 approached this honorable court on 8/6/2023. Thereafter, on 12/6/2023, honorable single judge had directed to consider the representation of the respondent number 5, my lord. Thereafter, they have rejected on his request. Transfer order has been passed on his request, my lord. On that ground, they have rejected. Thereafter, again, the present respondent challenged this order before the honorable single judge, my lord. Honorable single judge, in that case, I have filed a gabbat petition, my lord. Thereafter, honorable single judge quashed that transfer order, my lord. Your lordship kindly see page 118, relevant for.
Heard Miss D.K. Patnaik, heard counsel appearing to the appellant. So there is an interpret appeal. Telling the order of the land single judge. Dated 30th August 2023, passed in WPC number 21801 of 2023. So, this Patnaik council has submitted that the first transfer, the transfer order dated 3/6/2023, by which the respondent file was transferred, was issued on his own request. And in his place, the present appellant was transferred and he had joined that post. The respondent file had challenged the state order dated 3/6/2003 But the land is single judge by a separate order, by an order first pen, which that first order.
First order, page 88, 18544 of 2023.
Page 88.
My lord. On 12/6.
That is single judge by the order dated 12/6/2023. What is the name of respondent number? What is the name of the
Kartikeswar Pradhan.
By the order dated 12/6/2023, within bracket delivered in WFC number 18544 of 2023. Disposed of the repetition, directing consideration of the representation which lead to the petition. So, on due consideration, the transferring authority rejected his representation by the order dated this is the rejection order.
Page 98, madam.
Why is it is written by the order dated
7/7/2023 in top, madam.
Page 98.
Madam.
Where it is rejected, what is the order is rejected?
Page 98
is hereby disposed of.
Disposed of.
Was disposed of. Not rejected. The disposed of is a representation without making any modification. So, being agreed, the respondent file has filed a further interpretation before this court, the WPC numbers
page 109.
What is it? 121801?
Madam.
Plus 2023. By directing the competent authority to consider the representation of the petitioner within the parameters of the transfer guidelines, which provide that no officer should be in legal force transferred within a period of 5 years. That effort, London senior judge having referred to the Vardara was a state of Karnataka and others. Here 1986 SC 1955 has observed that what is the post they are holding?
Assistant Executive Engineer.
Who is that? That the
page 66.
If the transfer order is implemented, the respondent file will suffer dislocation in his family. So, this Patna Land Council has submitted that the civil judge has not properly read the ratio of the Vardara, the Vardara Sopra. So, The order of super deals with the categories of employees belonging to Group D and Group C. Not in the officer rank. Are you submitting it? Huh? Unless you submit, it will continue. Stop. The department is Patnaik when the council has submitted that transfer guidelines doesn't give any right to an employee. It is a document for the guidance that the authorities will transfer.
And that judgment was referred by the writ petitioner, not in support of his claim.
I'm saying that she is opposing that judgment cannot apply to the present case. Because the judgment categorically said Vardha Rao, then it is relating to the Group D and Group C employee who are low paid, cannot make the two establishment for them, transfer will make the life, and there will be causing the dislocation for them. The para 6 of that judgment. So, did it assume made? Admit this appeal. Did it assume made? Let us admit this appeal to be heard in marriage. So, you are still there.
My lord, since 7/6/2023, I am continuing, my lord.
So, as it has been stated, by Ms. Patnaik, that the appellant has been still continuing in the transferred place of posting, new place of posting. Admit, the admit issue notice returnable on October 2023. So, since Mr. P.K. Mudali and the council appears and works notice for 1 to 4 no notices called for. However, the appellant shall take steps to service notice and they will respond in 5 days to district AD within 3 working days. In I, what is your I number?
6963 of 2023, my lord.
6963 of 2023. Partners good night. So we direct that the posting of the appellant status with respect to the posting of the appellant shall be maintained till the returnable date.
Okay.
If you are there, it will be protected, otherwise not. How someone on seeking transfer can challenge it? He has asked you to transfer. No, problem has been created by you, not by the respondent of file. Once he is rejected, now again comes to the court saying, you have not read the Vardha, I am sure. Pass this order. Just consider that aspect. Because this respondent of file is given so many places, not only the one place. Why don't you accommodate respondent number 5 in a different place? Let the appellant to continue in the same place now. Just consider that aspect of the matter.
Observe one line.
So meanwhile, we grant leave to the respondent number 1 to 4. Respondent number 1 to 4 to consider the transfer of the respondent of 5 to any other place as referred in his representation except the place where the appellant is posted.
Oh, please.
Right.
Urgent certified copy in course of the day.
It will not be typed and corrected in the course of the day. Okay, urgent certified copy be issued as per rules. 16th also.
Item number 2.
A copy of this order is supplied to Mr.
Item 2, sir.
May I please? I have challenged NSS 6, which is the report of the learned locates at page 67.
Yes.
On the ground that in the preliminary inquiry report, there are many.
Why this petition, this appeal petition went in 2021?
My lord.
Why the urgency?
But the urgency is that.
Well, it's in the matter of 4th of October. It's the matter of 4th of October 2022.
Item number 3.
May I please, Your Lordship? Well, this writ appeal has been preferred by the government, my lord. But this is a matter which is covered by a Lordship judgment.
Your Lordship, there is a delay of about 100 years.
Which judgment?
My lord?
Rehabilitation matter.
Yes, my lord, rehabilitation matter.
Well, here there is a very interesting factual aspect. There is the pleading of the respondent is that he submitted the application on 16th February 2019. But if your Lordship may kindly come to page 55 of the writ appeal.
Yes.
Your Lordship, at page 55, this is an affidavit of the respondent, which is appended to the application, and your Lordship will see over the page 56.
Yes.
Very last line of that page, dated the 11th of September 2019.
Yes.
Therefore, how could application have been filed on 16th February?
Lordship may come to Annexure 5 of the writ petition. Well, everything will be cleared, my lord.
No, clear that you have claimed, but your affidavit is much after the date of submission.
Your Lordship,
my lord.
even if an application has been made on 16th February, that will be considered an incomplete application until this affidavit has been made. So the final date of application is 11th of September.
So you consider the judgment says that only if it is covered by the scheme. It is not, that judgment is not decided. You will decide. He said within their judgment only because of the interplay between the old and new rules, nothing else.
Your Lordship.
So we can say the delay is condoned.
Yes, my lord.
Guided by this judgment. No? You have written this one of the judgment. Delay is condoned. This one, yes. They just say the same thing. No, that almost happens. No, there are 6 will not be there. The person will be there. You leave this first IA. IA for condonation, which one is there? It's a 2722 of 2023. Heard Mr. Arnav Behral and Instant Counsel. Appealing to the appellate applicant, this is an application to section 5 of the Litigation Act for condoning the delay of no delay. I change it. Delay 117 days in preparing the intercourt appeal against the judgment, against the order dated 20th December 2022, delivery WPC number 34376 of 2022. So, you have not filed a Vakalat now?
Today I am filing, my lord.
Mr. K. Swine Learned Counsel has entered in the appearance and submitted that he will not have any objection if the delay is condoned. In view of the stand taken by the opposite party petitioner, the delay stand condoned. The result is interlocutory application is allowed in this post of stop. Then now WA stop. You have heard Mr. In view of the order passed in our his appeal has been taken up for consideration. We have heard Mr. E. Behra and Regional Standing Council appealing to the appellants. And also Mr. K. Swine and Council appealing for the respondent number 1 in the writ petition. By the order dated why is that order page?
Page 69.
Have we got a copy?
Yes, madam. Just now. Page 69, madam.
Order dated 24/2022. And single judge has observed as follows. Observed as under paragraph 5, no? Page 71. So, we disposed of this appeal in terms of the order dated 25/9/2023 in state of Orissa and others versus Bindu Shagu Sumantra and others. Regarding WA number 810/2021. So, the same judgment stop. We reiterate that the case of the respondent number 1 shall be considered in the manner is recorded in state of Orissa and other verses Bindu Shagu Sumantra and others within a period of 4 months from today. To that extent, the interim judgment stand modified. So, a free copy of this order is supplied to Mr. Behra, Regional Standing Council. Next, urgent certificate copy of this order is granted as per rules.
Grateful, my lord.
Item number 4, WA 1172 of 2023.
This appeal has been filed by the state. Madam, kindly straight down to page 20. Page 20. The prayer made in the writ petition. It is therefore prayed that this honorable court may graciously be pleased to admit the writ application, call for the records, issue rule calling upon the opposite parties, particularly OP numbers 3 and 4, to show cause as to why the petitioner shall not be disbursed with the bill amount of rupees 1,86,000 after completion of the work, so and so. Now, my lord, may turn to page 13. No, page 25. Page 25, paragraph 4, that is our stand in the counter affidavit for the Honorable Single Judge. That is humbly submitted that the writ application as led is misconceived in the facts as well as in law and is not maintainable in the eye of law, and therefore the same is liable to be dismissed. Then paragraph 5, first paragraph is not required, but second paragraph at page 26, sub-paragraph. It is pertinent to mention that on the basis of the application of the petitioner, a work order dated 1/5/2012 was issued in his favor by the OP number 3 for excavation of a multipurpose pond under MGNR EGS with an estimated amount to the tune of 1,15,000. Accordingly, the OP number 4 had moved to the proposed excavation site and contacted the petitioner to give the layout of the excavation work and to intimate the Gram Panchayat office to deploy manpower job card holder for the excavation work as per the norms of MGNR EGS. But the petitioner was reluctant to start the excavation work then due to self-illness. The petitioner has also intimated the said fact to the OP number 3 in his representation dated 8/9/2014. In the said application, he had requested to the OP number 3 to cancel the work order dated 1/5/2012 and issue a fresh work order. Hence, it is not true that the petitioner had excavated the tank on 3/5/2012 and the bill amount was not disbursed to him. Subsequently, basing upon the representation dated 8/9/2014 of the petitioner as at Annexure A to this reply, a fresh work order was issued by the OP number 3 with a revised estimate to the tune of 1,86,000 for excavation of multipurpose farm pond under MGNREGS having water area of acre 0.50 over the same piece of land. After issuance of the fresh work order by the OP number 3, the opposite party number 4 again moved to the proposed site on village Siundi Ganeshwarapur on 15/4/2015 to give the layout of to the petitioner for the excavation. But he found that a small pond with approximate water area of acre 0.20 has been excavated in the same scheduled land in Mo Pokhari Yojana under MGNREGS through Block Development Officer Pujan Jagatipur during the financial year 2011-12. The opposite party number 4, when moved to the office of the Gram Panchayat Talpada to inquire into the matter, found that on the basis of the application of the petitioner, work order was issued by the Sarpanch Talpada Gram Panchayat for excavation of a pond under Mo Pokhari scheme under MGNREGS for the year 2011 over the said scheduled land, which was surveyed by the opposite partners for excavation for multipurpose farm pond during the year 2012. The pond under Mo Pokhari was completed during 2012 and 13, and an amount of 37,716 was released in favor of the job card holders work for the excavation work. The next paragraph is paragraph 7, last portion at page 29. Hence, the claim of the petitioner that he has excavated the pond under MGNREGS by spending his own money is not true, as the same is not permitted in the guidelines of the MGNREGS.
As Mr. P. Not delayed, there is nothing.
No delay.
In trial.
Yes, it order was passed on 9/5, it was filed on 27/5.
All right. Heard Mr. P. K. Mudalil and Division Government Advocate. With an intercourt appeal challenging the order dated
page 44, 9/5/22.
Challenging the order dated 9 May 2023 targeted on civil judge WPC number 175 of 2021. Mr. Mudalil has Mr. Mudalil and District Government Advocate has submitted that there is no admission about the claim of the petitioner respondent. There is several breaches in execution of the.
In fact, he has not executed for the claimed amount. That is our case.
So there is the basic objection is raised in the counter with the respect number 1 to 4.
Yes.
Is that the lead petitioner respondent has not executed even the work of the excavation under the
MGNREGS.
MGNREGS. What is the name?
Yes. MGNREGS. Mahatma Gandhi National
Rural Employment Guarantee Act.
MGNREG.
Yes.
Scheme. Stop. According to Mr. Mudalil, this is a question whether such dispute can be entertained by a court in exercising the jurisdiction under 2026 of the Constitution of India. Admit the appeal issue notice returnable on 3rd of November 2023. The account shall take steps for service of notice on the sole respondent, I think.
Yes.
Sole respondent. Within 3 working days from today. In IA,
there are two IAs. One IA
in IA number 3049, you have filed also this
dispensing with. You have to grant me 2 weeks time in the meantime.
You should first move the application.
Sorry.
All right, in IA 3049, Prime Minister P.K. Mudavadi, there's an application for staying the operation of the state infant order. In view of the grounds that was taken in the memorandum of appeal, we stay the operation for the state infant order in the returnable date. Issue notice on the opposite party, returnable on the same date. The steps for purpose of servicing notice be taken by the applicant applicant within 3 working days from today. So in another miscellaneous application, there is an application for dispensing with the filing of the certificate copy of the infant order. So, Mr. P.K. Mudavadi and additional government advocate who has submitted that for urgent filing, they could not obtain the certificate copy in time. For the reason they have filed the appeal with a downloaded copy. So, we do not find any impediment for dispensing with filing of the certificate copy subject to the condition. The certificate copy shall be filed within the returnable date. In terms of the above, this application stands allowed in this post-law. There is a 1993 Supreme Court decision in the Eureka Computers Limited versus State of West Bengal. Then the law has been laid down where in such cases the court can, regarding the money claim, only if the government admits an amount found to be admitted.
That is also in 2003 or 5.
That has been limited. That was the basic judgment. Paul?
Last matter. Rate Appeal 1526 of 2023.
Mr. Kuntia is absent, so.
Well, there's close to 300 days delay. Lordship may issue notice.
Mr. Rivera, run it. Division standing counsel. Is I 4034, huh? 4034. This is an application in the section 5 of the Litigation Act for condoning the delay order. Beyond 10 days, as per the stamp report, in filing the intercourt appeal from the judgment, the order dated 5th August 2022, for the Lancashire judge in WPC number 2644 of 2008. Issue notice as to why the apprehension delay shall not be controlled, or any other orders or orders shall not be passed as being fit in the circumstances of the case. So, the notice is made returnable on 3rd of November 2023. The applicant shall take steps for service of notice on the opposite party. In 3 working days, they will start posting the